All right, so let's talk about Judge Samuel Junkin again and this brand new order of recusal he just filed in the Timothy Vess Benton case. This is one of the most outrageous, contradictory, and downright insulting orders I've ever read. This guy is a complete joke. And I'm going to break it all down for you right now. And so we're going to go through about 30 minutes of the truth here, because that community, the state, and the victims and their families all deserve better than this weak attempt to cover his tracks. Let's not forget, Benton pled guilty to essaying young boys, and he was sentenced to 17 years. We're not talking about a shoplifter. We are talking about a child, a true child predator, period. I am going to read the order, and I've also placed the full order down here. And I will place these in the comment too, so they can be easily read. On June 25th, 2025, and this is quoting Judge Junkin from the order, I entered an order transferring Vess Benton into the Community Corrections Program for the 24th Judicial Circuit. The law grants me complete discretion on placement of eligible defendants into the Community Corrections Program, and this decision was made solely by me, without the input or approval of the victims' families, the defendant's family, or the district attorney. Now, here's two things we know he's lying about for sure, because or either him or one victim's father's lying, and we're going to figure out which one is actually lying, because we're going to call them both out. So the judge says he did not get input from anyone, but the one victim's father state, and I'll put his post up, that he did get input from him. So again, one of them two are completely lying. And the defendant's family, he states no input from the defendant's family. So we're supposed to believe that it was a sheer coincidence that the victim's family bought this beach house not even 2 weeks before the order came out. And that was just out of 5 years, complete coincidence. This circuit court judge is bold-faced lying to us in a court order. Again, this guy thinks we are all complete idiots, because if this isn't insulting our intelligence, nothing is. Let's get back to it. Since the entry of the order, there has been significant public frustration regarding my decision and the lack of explanation. I understand that frustration, and I will attempt to provide context here. If you don't know anything about statement analysis, his word usage here is very telling, because what he is saying is, I can't tell you. What that means is I cannot tell you the real reason, but I'm going to attempt to provide a reason. Statement Analysis 101. On May 19th, 2016, Mr. Benton was involved in an automobile accident that resulted in a traumatic brain injury that left him with severe cognitive impairment. Approximately 1 year later, he committed acts that eventually resulted in his conviction of 2 counts of SA. On November 27th, 2019, Mr. Benton entered a guilty plea. Let's stop right there. This judge is trying to say, now this is his words. On May 19th, 2016, Mr. Benton was involved in an automobile accident that resulted in traumatic brain injury that left him with severe cognitive impairments. Approximately 1 year later, he committed acts that resulted in his convictions. This judge is trying to excuse, and there's no other way to look at this. He is literally trying to excuse Benton's behavior, Benton's crimes, over a traumatic brain injury. That is highly insulting to anyone else that has suffered a traumatic brain injury. I'm not a medical expert, but I would bet there are no studies linking traumatic brain injuries to committing these heinous child crimes, because there are a lot of people that suffer from traumatic brain injuries. They all don't then go find little boys and do bad things to them. Again, this is, as I said in the beginning, this is ridiculous. This is insulting. This entire order, unbelievable. In fact, Mr. Benton entered a guilty plea and was sentenced to 17 years in the custody of the Alabama Department of Corrections. This was an agreement reached between the district attorney and Mr. Benton and his attorneys, and it resulted in the dismissal of the remaining charges. So, but yeah, he is spending half of this order, literally half of it, making excuses for Benton. And if I wasn't clear, let me be clear. This is not about a car wreck. This is not about a traumatic brain injury. This is about what Benton consciously chose to do to children. Just want to make sure we all understand that. And the fact that Junkin keeps humanizing Benton, while minimizing the trauma of those kids is, again, very insulting. Back to the order. The Alabama Department of Corrections is responsible for the health and safety of all inmates in its custody. It is well documented that the Department of Corrections faces great challenges in trying to provide for the health and safety of its inmates, especially inmates with significant mental and psychological impairments. Before entering the custody of the Department of Corrections, the defendant provided the necessary medical documentation to put the department on notice of the potential complications of his incarceration and allow the department time to prepare for his placement. Judge Junkin is acting like Benton is the first inmate the Department of Corrections has ever taken in. Despite being given this information in the 5+ years that Mr. Benton has been in the Department of Corrections, providing for his health and safety has proven to be not only challenging, but oftentimes impossible. Y'all forgive me if I find it hard to have empathy for this horrible excuse for a human child predator, even though Judge Junkin it's obvious Judge Junkin is way more concerned about Benton's health than the victims of Benton. That in itself raises a lot of questions, I would say, for sure. Several months ago, I learned that Mr. Benton was going to be considered for parole in October of this year. Him saying he learned that he was going to be considered for parole, it's not a secret. Like, it's not something that just pops up. They don't determine 3 weeks before that, oh, we're going to put this guy up for parole next week. It's not the way it works. He knew when his parole was going to be coming up, or his parole hearing. Shortly after learning that, it became clear that Lee Brothney, who was then the chair of the parole board, would not be reappointed to that position. This was significant in my mind because although the parole board was under intense pressure to increase the number of defendants being released on parole, Ms. Gaffney was consistent in her denial of granting parole to defendants, despite significant public backlash. Faced with a changing parole board and pressure on the board to increase the number of paroles granted, I became concerned that Mr. Benton would be granted parole. He just spent half the order talking about Mr. Benton's impairments and his mental health. But now all of a sudden, in between one paragraph, now all of a sudden his entire mind has changed to, this is not about Benton, and not about Benton needing to be out of prison. This is, I was afraid he's going to be paroled. And so I didn't want that to happen. And that's the excuse we've heard. That's the excuse that people were messaging me about. And now that the judge is admitting that no one at the parole board told him that Benton was probably going to be paroled. Nothing like that, which is what we said from the very beginning. We knew that wasn't true. We knew he made all that up in his head. Well, he's actually being honest about it now, at least. So I'll give him that. But he needs to figure out which one of these excuses was he really trying to throw out here. I guess he couldn't decide which the best one was, so he just said, I'm just going to throw all the excuses out there, even though they completely contradict one another. And he goes on, I did not then and do not now believe that to be in the best interest of the victims and their families, this community, or Mr. Benton. Okay, let me reread that sentence, okay, just so so he starts this with, I became concerned that Mr. Benton would be granted parole. If paroled, Mr. Benton would be released from the Department of Corrections into this community without significant restrictions or supervision. I did not then and do not now believe that to be in the best interest of the victims. I agree with that. The families. I agree with that. This community. I agree with that. Or Mr. Benton. So you're trying to now act like if Benton were released from prison, it would not be in the best interest of Benton. Make that make sense to me, someone. Someone make that make sense to me. This judge. It is a sad time when the state of Alabama has circuit court judges this ignorant. Sad time. Accordingly, in order to ensure that Mr. Benton would not be paroled, I made the decision to place him in to the community corrections program on house arrest with GPS monitoring. Since he is no longer eligible for parole, he will be required to serve the balance of his 17-year sentence on house arrest and forced to comply with the current restrictions set out in my order and any future restrictions imposed by this court, which includes receiving intensive and continual mental help treatment. So again, the judge is just going back and forth. He's trying to act like he was very concerned with Mr. Benton's mental health and the way he was being treated in prison, which that is probably true. That is, I'm sure, why Benton's family wanted him out of prison, and why whatever they did to make this happen, that's why they did it. But the judge knew that he couldn't just have that as an excuse. Why? Well, because if that's your problem, judge, with this, then you need to let everybody out of the Alabama DOC. I'm not trying to be funny here. DOC is not a nice place. It's not the safest place in the world. I'll be the first to admit it needs to be safer for the inmates. It needs to be a lot better, but it is not. In fact, it's one of the worst in the country. So I agree with that. However, I don't agree with letting all the criminals that's in DOC right now, just let them out just because it's not the best environment right now. And I don't think any of you would agree with that either. So Junkin knew that that wouldn't fly. He's also trying to spin this in, he believed all of this was in the best interest of the victims and the victims' families and the community. Much has been made about my decision to allow Mr. Benton to travel to the Benton's family's home in Gulf Shores. I anticipated a negative response to this ruling, and I believed it would be in the public's best interest and in the interest of Mr. Benton as well if the Bentons were allowed to temporarily or even permanently relocate. I know I don't have to explain all this word for word for y'all because y'all are intelligent, even though the judge is an idiot. But I just want to make sure that I'm being completely clear in what he is saying here. This judge, this circuit court judge, really, in a court order, just said that he believed it would be in the public's best interest, for Mr. Benton to get to travel back and forth to his beach house. When I first read this order, I had to verify that it didn't come from Babylon Bee. But Babylon Bee, as good as they are and as funny as their posts are, they couldn't have made this up. I don't think anybody could have. All right, let's resume. However, after the order was entered and a site investigation was completed, it was determined that the home does not comply with S Offender Registration and Community Notification Act regulations, and therefore is no longer an option. He's talking about the beach house, obviously. Well, I hate that for him. You see, this judge did so much homework. He now has admitted that he willingly was trying to allow Benton to go to a house that he knew violated the SORNA Act. So either the judge did absolutely no research on any of this and then just put it out, or he's lying about not knowing that it violated the SORNA Act. I'll let you choose which one you think it is, whether he was just a complete idiot or whether he's just completely lying. Following the entry of my orders, members of the community began to question whether Mr. Benton's placement in community corrections actually disqualified him from being paroled. There was even some suggestion that his placement in community corrections made it more likely that he would be paroled in October. So on August 25th, I contacted Lee Gwathney to confirm that Mr. Benton was no longer eligible for parole. I generally discussed my order with her, and she directed me to Eric Anderson, Deputy General Counsel for the Board of Pardons and Paroles. Mr. Anderson confirmed that placement in the community corrections eliminates a defendant's eligibility for parole, and on August 28th, he sent me an email with the controlling statute. That email was forwarded to the district attorney and defense counsel on the same date. So at least the judge is admitting he doesn't know what he's doing and doesn't understand the job, because what it sounds like from his own words, that he started telling people that he did all this for this completely ignorant reason that's not true, that he did all this just to keep him from being paroled. But then when people started pushing back on, well, I think he can still get paroled, then he scrambled and had to find out for sure if that were the truth, which he did. Luckily for him, it was the case. But this is a clear minutes of him stating he didn't really know. I recognize the hurt that my decision has caused the victims and their families. This was an incredibly traumatic event in their lives, and it is not lost on me the pain that has resulted from these most recent events. I also recognize this was an unpopular decision in this community, and I have the utmost respect for those who disagree with their reasoning. But this job requires me to consider all the information available to me and make what I consider to be the right decision based on the totality of the circumstances. That is precisely what I tried to do. Mr. Benton's placement in the community corrections program ensured that he would not be released on parole into the general public, but would be confined to a specific place. So, no, It wasn't to a specific place. It was his family's home, his dad's business, his beach house. He was getting to travel all over the freaking state. And he would receive the necessary cognitive and psychological treatment that hopefully prevents this from ever happening again. I believe this to be the best available resolution, and I stand by my decision. There has been, the experts of experts on child predators, all the highly recognized and most well-respected psychologists that's studied this stuff. And it has been found time and time and time again that you can't fix this. If you ever speak to someone that's committed acts like this and they're honest with you, they will tell you it's not something that can be fixed. But this judge, he literally thinks he's smarter than everybody. That's why he's stating he didn't ask the victims' families about any of this. He didn't get any advice from anybody before making all of these decisions, because apparently he thinks he makes the best decisions ever. And now he thinks that he can fix Mr. Benton and fix him to where he would never want to hurt children again. Again, this has been studied numerous times. There is zero evidence out there pointing to any fix with this. These people that do this, they're evil. There is a big difference between someone making some bad decisions and being dumb and being evil. If you're evil, there's no fixing that. All right, we're on the last paragraph. However, since the entry of this order, I have had significant contact outside of court with the families of the victims and the defendant, as well as the attorneys appearing on both sides of this case. As a result of this contact, as well as the media attention generated by my order, I am of the opinion that my impartiality could reasonably be called into question. Accordingly, pursuant to Canon 3C of the Canons of Judicial Ethics, I hereby recuse from the above style case. Here's the biggest problem I have with that last paragraph. He is still trying to say that he did not have contact with Mr. Benton or his family before these orders were released, before he put all the previous orders out. That is a lie. And if the proper authorities want to actually investigate this, that'll be very easy to prove. Because all you got to do is pull phone records. I would bet everything I have that he had contact with the Bentons before any of these orders were put out. But in this court order, he is clearly stating that never happened. That's going to be an easy lie to prove. The judge has realized he's gotten in over his head. He thought that he was so powerful, he could make whatever decisions he wanted to, and there would be no backlash. But now that he's figured out, no, we're fighting, a bunch of us, he's trying to change his tune now. Now, it is awesome, and it is a great day that he has recused himself from this case too. Can't ask for anything better right now. But that still doesn't take back him doing this in the first place and the reason he did it. And I'm not going to stop, and I know a lot of others are not going to stop until he is held accountable for this decision. But him, in this order, he wants us to believe that he is the hero, stepping in to keep Benton from walking free. But we know the truth. His order gave Benton a cushy house arrest setup where he could still manipulate the system. And that's all Vess Benton has been trying to do this whole time. Him and his family, they're trying to manipulate the system. They're trying to get people to feel sorry for them because he had this traumatic brain injury. But as I've stated, there are a lot of people with traumatic brain injuries. They don't then go out and do these horrible things to children. And then with him admitting significant contact with them outside of court and all the media attention that he's gotten, we can translate that. He does know his impartiality is gone. He knows that we have caught on. And this recusal is not about ethics. Trust me. It's about damage control. That's all he's worried about now. If he were truly impartial, you wouldn't need to recuse. You only recuse when you've lost credibility. And make no mistake, Judge Samuel Junkin has lost all his credibility. And again, now he's trying to do the damage control to try to get some of that back. It's not going to work. Including this order tries to sound professional, but it reeks of excuses. This isn't a professional recusal order. It's a order of excuses that contradict themselves at that. And since all this has came back up, since he allowed Benton back out, the families have had to relive all that trauma. The victims have had to relive all that trauma while watching Benton get special treatment. And then now hearing the judge lecture them about why it's actually better for them. Again, this is unbelievable. This state The 24th Judicial Circuit deserves judges who put victims first, not predator. This case shows us exactly why Fayette County, all of Alabama, need accountability in the courtroom. Judge Junkin may have recused himself, but the damage, as I said earlier, already done, and we're not going to stay silent about it. Let me be clear. Junkin's order of recusal is not noble. It's not about protecting justice. It's about protecting himself. He contradicted himself and tried to spin the story, but he failed. Shocking, right? And now it's on us, the people, us advocates, to keep shining the light and demanding accountability here. Because if we don't, this same game will happen again with another predator and another family. We can't let that happen. Truth, justice, and accountability. Truth, justice, and accountability. That's what we're fighting for. That's literally one of the mottos I've put on our new merch, and it fits perfect right here.